Everyone, I'm Kelsey Affronte, and I am an attorney here at Beresford Booth in both the litigation and family law divisions. And today we're going to be talking about when you can get a protection order. This is going to be kind of a general overview because protection orders are complex. So where can you find more information about this? You can schedule a consult with me. I have been working on domestic violence and anti-harassment protection orders since 2017 when I was a Snohomish County prosecutor. And I've had experience with vulnerable adult protection orders since 2022. You can also look to the statutes and court resources, including RCW 7105, which is the chapter that applies to protection orders, and the website where all court forms are listed. So that would include the petition, the order, declarations. There's even a brochure related to understanding Washington protection orders and instructions on filing a petition. So those are helpful resources as well if you're trying to do this on your own. So what is a protection order? Really, it depends on the type of protection order, but a lot of the terms remain the same. So it restrains the quote unquote bad guy or restrained party from breaking the law. There's some terms in there that would be a violation of the law in general, including they can't harm, assault, harass, threaten, or stalk you, right? Those are all crimes in and of themselves. But they also can't contact you, not directly, not having, their brother or cousin call you on their behalf, which would be indirectly or through a third party. And they can't come near you and various other places, including your home, school, workplace, car, your child's daycare, various places like that. And sometimes it prevents them from possessing weapons and firearms, depending on the findings by the court. But again, the terms vary depending on the type of protection order that you are seeking. So, for example, in a domestic violence protection order, you might request domestic violence treatment or that they are required to delete any intimate images they have of you. For a stalking protection order, they could be subject to electronic monitoring to ensure that they are not coming within a certain distance of you or stalking you. If the protection order applies to minors, it could restrain the other party from having custody of the children or removing them from the state or interfering with your custody of the children. And for a vulnerable adult protection order, it could require that they provide an accounting of any financial moves that they've made on quote unquote on behalf of the vulnerable adult or restrain them from transferring any property of either themselves or the vulnerable adult. So terms vary from order to order, but the main terms remain the same. So how do you know what order you need? It used to be that if you filed a petition for a protection order and it was an anti-harassment order, but you actually met the definition of domestic violence, intimate partners, then what would happen is the court would actually dismiss your petition because you filed the wrong one. Now that cannot happen. Instead, a petition now must not be dismissed or denied on the basis that a conduct alleged would meet the criteria for another type of protection order. And that means that the court can determine what protection order is the most appropriate. So you're no longer at a high risk of losing your protection order because you checked the wrong box. For the types of protection orders, there is domestic violence, sexual assault, stalking, vulnerable adult protection order, extreme risk protection orders, and anti-harassment orders. And these are all defined by statute. So, as you can see, this covers a wide variety of circumstances. Will you be granted an order? That is a great question. So the burden of proof that you have to me as the petitioner is a preponderance of the evidence. And that just means that the facts that you're alleging more likely than not occurred and that they meet the elements or what you need to prove depending on the type of protection order that you need. And so the burden is relatively low for these types of petitions because the goal of the statute is to protect the petitioner from these types of conduct. The way that you determine what elements you need to prove really depends on how the parties are related, right? And what conduct you're alleging. So in a domestic violence protection order, the parties are either intimate partners, family members, or they live in the same household. In a sexual assault, stalking, or anti-harassment order, sometimes the parties have no relation at all. They could be neighbors, coworkers, any variety of relationship or lack thereof. In an extreme risk protection order, the petitioner has to be either somebody who meets the definition under the domestic violence terms or a law enforcement agency. And in a vulnerable adult protection order, the vulnerable adult has to have the inability to care for themselves or needs assistance to do the same. So this kind of gives you an overview for the type of order that you might need depending on the relationship to the other party or to the vulnerable adult. The next question is, what did the respondent do, right? What did the quote unquote bad guy do? In domestic violence, they would have committed domestic violence against you or your children. Sexual assault protection order would be non-consensual sexual conduct. Stalking, also defined by law. Harassment is an anti-harassment protection order, or in some cases, domestic violence if you meet the definition of the relationship. And in an extreme risk protection order, that's why I changed this slide to say respondent instead of bad guy. Typically, what you're doing is trying to prevent someone from harming themselves or others. And in a vulnerable adult petition, the vulnerable adult or someone on their behalf can petition to protect that vulnerable adult from abuse. This is where things get tricky, is all of these protection orders and the elements that you need to prove are defined by statute. And that gets complicated very quickly. So don't try this at home. An example of how tricky it gets. Domestic violence, as we just said, has a definition of what a domestic violence relationship is, and then a definition of what conduct meets the definition of domestic violence. A form of domestic violence is coercive control, which has 18 subsections and examples of what coercive control could be. Unlawful harassment, if you have the domestic violence relationship between the parties, also has multiple defined terms, including the definition of harassment and the course of conduct. But when the court is looking at the course of conduct you're alleging meets harassment, there are actually 6 factors that the court considers as an exception to that harassment, meaning that it would have a legitimate or lawful purpose. So those are also defined. Vulnerable adult protection orders. Abuse has 5 potential meanings. So just listed below are some examples, including abandonment, isolation, and neglect. These are 3 separate defined terms. Chemical, mechanical, and physical restraint are also 3 separate defined terms. And financial exploitation is a defined term with 3 separate subsections. So the statute is lengthy. This is all in RCW 7105010. And it can get complicated to figure out whether you've met a definition of one of these terms, because first of all, they're not organized by the type of protection order, they're alphabetically organized. So you have to go through and kind of track, okay, domestic violence equals coercive control equals X. So you kind of have to track through in order to determine if you can meet your burden of proof to be granted a protection order. If you are pursuing a protection order, there are multiple steps. So the first step is that you file your petition, and that happens ex parte, meaning the other party has no notice that you have filed a petition, and the judge reviews it separate from giving that person notice. If you meet that threshold preponderance of the evidence, or the court thinks that you might in the future, the court will issue a return hearing. If you immediately meet that threshold, the court will enter a 2-week protection order called a temporary protection order and give notice of a hearing. If you don't immediately meet that threshold, but the court believes that you can, the court will set a return hearing but will not issue a temporary protection order. And then between that ex parte hearing and the return hearing, the restrained party will be served notice of the order, which has to be done 5 court days in advance in order for the hearing to proceed. So at that hearing, that's where you have a contested hearing. So typically both parties will submit written materials alleging whether whether the other party did or that party did not do the actions alleged in the initial petition. And at that contested hearing, the court will make findings as to whether you've met your burden of proof, what terms you've requested, and what they are granting, and enter a protection order typically for 1 year. At that point, once you have your protection order for a year, the next steps could include renewal, modification, or termination. So renewal is a petition by the petitioner, so the protected party, to renew the protection order at near the end of that expiration date a year later. And at that point, the burden shifts to the other party to show that there has been a substantial change in circumstances, demonstrating that they will not engage in the actions or type of behavior that led to issuing the protection order. So the protected party no longer has a burden of proof once the protection order is entered. A modification or termination. Modification can be filed by either party, and that is to revise some terms or provision of the protection order. For example, creating an exception to contact. Maybe you need to have direct written contact, so you bring a modification so that you can have text message or email contact about a specific subject, but that any other contact would be a violation. And termination is typically filed by the restrained party asking the court to remove the restraining order. For modification and termination, typically the same standard applies. The restrained party has to show that there has been a substantial change in circumstances that demonstrates they will not re-engage in the type of behavior that led to the issuance of the protection order. So just because you got a protection order doesn't mean it's over, right? Some people are done at the end of 1 year. Maybe it was a dispute between neighbors that's resolved, or that person has moved and you're no longer afraid or experiencing emotional distress. So you don't need it and you just let it lapse. But most people who, in my experience, have filed for a protection order want it to extend beyond that 1 year because the basis for their protection order was so severe that they're still afraid of that other party, or maybe they know that the other party hasn't engaged in any treatment to mitigate that type of behavior, and so the fear for future domestic violence, harassment, stalking is still there. So as you can see, between the managing the court forms, determining the definitions of the parties or the elements that you need to prove by a preponderance of the evidence, you will be doing a lot of research if you're doing this on your own. So if you have questions or would like to learn more about a specific type of protection order and whether the facts that you have in your case will likely lead to the court granting a protection order, please don't hesitate to reach out and schedule a consult with us. And I'm happy to answer any questions that you might have. Thank you so much for your time.